in the month of March, my lord.
Why?
My lord, this month Mr. Goyal is appearing in this matter. This month he has some difficulties, my lord, personal difficulties.
Okay. The other side.
Lordship, I am for responding 2 to 4.
Any objection?
No objection, Lordship.
Yes. Okay. Right. After 4 weeks, after 3 weeks. Yes. 3 weeks, March.
March. Highly obliged.
Highly obliged, Lordship.
Item number 1.
May it please, Lordship. My lord, just I have noticed, my lord, the name of the respondent for the council for respondent not appeared in the cause list, my lord, for income tax department, my lord.
Yes, some notice.
So notice was served, my lord. Mr. S.C. Calvert, it seems in the cause list, my lord, their name has not been appeared, my lord.
So what are we to do?
Lordship may take up in the absence, or otherwise, my lord, maybe perhaps, just I noticed, otherwise, nothing, I can proceed, my lord. The names were not there, my lord.
Yes,
Mr.
MS Emerchang. You are
Respondent number 1, Lordship.
number 1 is the union.
Union, my lord, and respondent, remaining respondent,
Attendance.
respondent number 2, 3, 4, 5 are from income tax department, my lord.
Yes.
Mr. S.C. Cal, copy was served to him.
You are seeking for interim orders.
Yes, my lord, I am seeking intent, that's why, my lord.
Then we'll have to.
Then day after tomorrow, if Lordship permits, I will inform them that matter is fixed on
Tomorrow, the bench won't be there. We'll have to take it next week.
next week, my lord.
Yes, sir. Heard, Mr.
R.S. Mishra, my lord.
Arrest Commissioner, Council, the petitioner issue notice. MS Emerchang, Vice Dr. N. Mozika, let CSGI present. We have respondent number 1. Though Mr. Mishra, those the Council of the petitioner submitted that notice has been served upon the respondents 3, 4, and 5. There is no appearance on their behalf today. For the ends of justice, let's this matter after 1 week. Yes.
My lord. Much obliged, your lordship.
Item number 2.
I'm not sure. We just submitted that text part. I'm not seeing the receipt notice. It's served.
May it please your lordships.
Yes.
Lordship, we're supposed to file affidavit in this
Affidavit,
matter,
what happened?
Lordship. We've recently received instructions, Lordship. I'm praying for some more time.
No objection.
No objection, Lordship.
Yes, Ms. Emerchang, Vice Dr. Musa, for the respondents, please point allowed. For the 2 weeks' time to file affidavits, yes.
3.
3 similar matter, Lordship.
Yes.
4. Lordship, in this matter, I'm seeking for accommodation of 1 week.
1 second. Let the file come. You are appearing in this matter now? I thought this is Mr. Dasgupta's matter.
Yes, sir is out of station. He is on leave till 12.
Where's the DSGI?
He's on Lex, Lordship.
When?
A week, sir, after a week, Lordship.
MSA Syndrome, Learned Counsel for the petitioner. Raise that due to absence of the arguing counsel, matter be adjourned for today. Not objected to by so the respondent is after 1 week, yes. I just want to finish it off next time.
Yes.
Nothing remains. There's no substantial question of law involved also.
5.
Whatever remedy already over.
May I please, your lordship? Your lordship, pleadings are completed. Kindly fix the matter for hearing, your lordship.
It's already fixed for hearing. It come for orders or hearing?
Orders. It has come
Orders,
for
your
orders.
lordship.
Okay, let the parties clear the matter be listed for formal hearing. When?
After 2 weeks, your lordship.
After 2 weeks.
Obliged.
Interim orders to continue. Interim order if any to continue.
There is no
Until further orders. There's no interim order.
no interim.
Yes.
Hearing. 7.
There is an interview.
There's an interim.
Yes.
Yes.
But 7 mallet will have to be deferred mallet because the connected mallet is still pending before the Honorable Apex Court.
Yes, Chris, this one.
Yes.
Item number
7 mallet. 7.
What connected matters?
Well, there's been a challenge to one of the orders passed by the Honorable Court before the Supreme Court. So that matter is pending on it.
What's the matter about?
This is with regard to, my lord, the seizure of gold, my lord, by the
Yes,
custom.
as it is submitted that the connected matters is pending consideration before the Honorable Supreme Court list after 6 weeks. He has to await any outcome.
All right.
Yes. 6 weeks.
Any mention?
May it please your lordship, I beg to mention item number 49.
Yes, my lord. No objection, my lord. It's seeking time.
39?
49.
49, my lord. This is a plantation, rubber plantation, my lord.
What's happened to rubber plantation?
The settlement talks will be held today, lordship. This
With the
happens-
pollution control board.
My lord, they're paying the compensation. This is why they've gone to the board, my lord.
2 weeks, your lordship.
May I please your lordship? Your lordship, I beg to mention item number 48.
Syed Hussain.
Yes, your lordship.
No objection.
No objection.
One.
Yeah, objection. No objection. Very good. Yes.
I beg to mention item number 1, your lordship.
Number?
Item number 1. The item number 1, your lordship. The conducting counsel for this
One
case.
from where? Hearing list.
It is
Motion matter.
yes, your lordship.
Don't mention order matters or motion matters. How many times the court will tell lawyers?
Pardon,
Who
your
is the
lordship.
senior?
Mr. S.R. Lindo.
You tell us this. Time and time again, you see the practice in the court. Don't mention matters. Only hearing matters will be mentioned. Yes.
Your lordship, similar prayer.
Don't mention. Mention when matters called out. Number 1.
Pardon, your lordship. Your lordship, then item number 58.
That happens, and even for filing affidavits, you start mentioning in the beginning, so you can run away. Yes. Yes.
I'll bless.
May I please, your lordship? Lordship, I beg to mention item number 51, lordship. 1, 2, 3. Lordship, my senior counsel is indisposed, lordship.
Mr. Dindo.
Yes, lordship.
No, my lord, that I understand, your lordships. That's all right, my lord, for today. But only thing, my lord, is more than 10 adjournments, your lordships. Only in the next day, your lordship, the matter is taken up, my lord.
After how long?
Lordship, let come on Tuesday, lordship.
Please, your lordship.
Next.
I'm appearing for respondent.
What's the matter about?
But this is, my lord, regarding promotions, based on, my lord, merit comes in your
Mr. Counsel?
Yes, only on the basis. Yeah.
Appearing for respondent number 5 and 6, the private respondent. Similar prayer, your lordship. Praying for time.
After 1 week, okay.
Highly obliged.
May I please, your lordship. I beg to mention item number 55.
Yes.
No objection,
No
your lordship.
urgency.
No, your lordship.
urgency.
No objection, your lordship.
Yes.
Highly obliged.
Oblige, your lordship.
May I please, your lordship? Your lordship, I beg to mention item number 46, your lordship. Miss N.G. Shilla is not available today. She's indisposed, your lordship.
No objection, your lordship.
You have no objection.
No, your lordship.
Yes.
Oblige, your lordship.
Much obliged, lordship.
I will appeal with problem.
Supplementary list, item number 1.
May it please your lordship, I'm praying you for lordship, kindly take up this matter at the end of the board, lordship.
This is an application under section 11 for appointment of an arbitrator. If there's any objection, they can file a response.
Lordship, Dr. Mozaka has some submissions to make, lordship.
All right.
Item number 2.
After some time, 1 more. Yes.
This is transfer petition, your lordship, but I believe your lordship has appeared as counsel in this matter.
Will be for any other bench or
3.
This is a transfer petition. I am the wife, my lord, and I'm a lower primary school teacher, my lord. I'm 50, almost retirement age, my lord. I'm residing in Tura and working in Tura. Marriage was also solemnized in Tura. My husband, my lord, is an IPS officer, my lord, who's posted in Shillong, and he's instituted this divorce suit in Shillong. So on the ground of convenience, my lord, I'm seeking for a transfer from Shillong to Tura.
Yes, sir. Heard Mr. Reading the application. If you notice, returnable in 3 weeks. Steps were taken in 3 days. Yes. But what stage is the divorce proceeding?
Well, we've just received notice. In fact, today is the first day. My lord, in fact, I filed an application for stay of the suit. I've just received notice. Today is the first day.
You
So,
put an
my lord,
application, they're saying you file a transfer.
my lord, deeply.
Yes.
Oh.
Please, Lordship, now this.
Yes. When is that? When is that? Yesterday.
Yesterday's matter is coming up on 26th, my lord.
Just on 26. Yes, this matter together with WC number.
The WPC number 602, my lord, of 2025.
5.
My lord,
Please, Your Lordship, I'm praying this matter also will be listed at the end of the board, Lordship.
notice may can be issued. This only as regard to the. They can file their response because this is pertaining to recruitment of Constable ZD. What has happened, my lord?
Does he have any specific submissions to make, or just generally asking for passover?
Can reply.
Lordship,
Just
his
generally.
presence is required, Lordship.
Why is it quiet? Okay. Might be for other purposes. Yes.
6.
Lordship, I have some prayer in this matter as well.
But there's been some protest from they're not appearing. After some time, okay.
Highly
Make a separate list for Dr. Mazika then.
daily decision.
My lord.
After some time, Mr. Kumar.
Deep, my lord, deeply, your lordship.
Where's that? Yes. Now you mentioned pardon matters. Yes. What do you have to say?
Your lordship, I apologize for.
You don't need to apologize. You all should learn. It's a learning process for everyone. Yes.
Your lordship, the conducting counsel is out of station.
You are appearing for respondent. What is your name?
Emla Pasam.
Who's your leading counsel?
And I Chaudhary.
And I Chaudhary. You record her name. So, Mr. So-and-so. Your name, sorry?
T. Islam, your lordship.
T. Islam. Yes, please that matter be adjourned for?
After 1 week.
After 1 week. As our counsel is not available. Just record her name. Present, we have the respondent. Because last time you're not present. Yes. Yes.
Hello, let's have a good day.
Well, they are already submitted.
Lordship, the challenge on maintainability, Lordship.
Is that is that
it should be tried by the tribunal under section 7I. So, Lordship, I learned
you had given that decision last time, Delhi High Court?
Yes, Lordship. I have given one decision from the from Delhi High Court also, Lordship.
What is your case, Mr. Sen? He said he already bought the wrong account.
No, my case, what happened in 2012, my lord, they switched over to online mode. For making submission, my lord, online mode, my lord, we need the activation. Now, my lord, we have approached them formally and said, please activate, you need to pay. We have we have given in writing, my lord, no, but they have not activated. And this situation continues till 19. 19, it was moment it was activated, my lord, we have cleared everything. So this is not in our hand, your lordships. And those, my lord, written, my lord, communication, other thing, everything I have annexed with the writ petitions. And my lord, so far, my lord, that maintainable, my learned friend has referred to a decision of Delhi High Court. Now, Delhi High Court, my lord, that single bench judgment has already been stayed. I have got that by the division bench. That is next
Supreme Court, you said?
No, my lord, it has not gone to Supreme Court. It has gone to division bench, my lord, and the matter is next fixed on 19/3/2026. Interim order to continue.
Interim order of stay.
Because yes, what happened, my lord, in that Gaurav Enterprise case, the Gaurav Enterprise case, my lord, that was a misinterpretation of High Court engineering. High Court engineering is the only decision which dealt with what will happen if an order is also passed, my lord, with regard to interest. Because admittedly, my lord, 7Q is not appealable. Now the Supreme Court has said, my lord, appeal is a creation of a statute. Now we just cannot confer the power. But there could be a situation where a composite order is passed. Now, my lord, what is the meaning of composite order, my lord? Composite order obviously means a combined order, not as two separate orders. In that case, he said, my lord, if one is appealable, one part is appealable, then an appeal should lie. But here,
the High Court textile case
lordship
says that interest and delayed payment of dues by employer. He also says interest, correct?
Yes.
Levy of reasonable project hearing now available to employee when composite order determining dues and interest is passed. Now your case is that the dues is different, interest is different. That's the only case.
Yes.
And so why can't the court read down that part and say that it'll amount to, it's passed the same day, correct?
Same day.
On the same day.
Same situation came, my lord. What I am saying, Gaurav Enterprise.
7Q and 7I.
Yes. Same situation, exactly same situation came in Gaurav Enterprise before the single bench of the division bench. Now, single bench of the division bench, single bench, my lord, while relying on the High Court engineering, looking into the High Court engineering, my lord, of the opinion, same there is same proceeding. What my lord is saying, same day order was passed. So why it should not be treated?
Inquiry is common, show cause is common.
Exactly, my lord, common.
Show cause is common.
Common.
Inquiry is common.
Inquiry is common.
Only orders, two orders are passed.
Two orders are passed.
On the same day.
Yes.
So that for you that's not a composite order.
Not a composite order. And exactly, my lord, there in the single bench.
Can we sort of segregate them? One you go on appeal, one you come by writ.
No, my lord, that will cause severe inconvenience.
And what will be the situation?
It will be severe inconvenience. And what happened? My lord, other thing, very
you pray that it is be taken up by this court only.
Yes.
Both interest and in the dues part.
No, my lord, other interesting part is what? No, so far Gaurav Enterprise is concerned, my lord, that separate order is not appealable. That is the stand, my lord, not taken by the employer, taken by the Provident Fund. And Provident Fund, my lord, against the order passed by the single bench, which says it can be treated, if same proceeding. Provident Fund filed an appeal, my lord. This appeal I am talking about before division bench is pending, my lord. That is filed by the Provident Fund.
Let's see the order where you showed just now.
It's
my lord, I have submitted a compilation.
No, that order, you have already submitted a compilation?
Yes.
Lordship, there is also one more judgment, Lordship, Rajiv Gandhi, from Delhi only. This is a similar order, wherein the
so this is the question that's plaguing the whole many high courts.
This is just not a technique. My humble submission, this is a substantial question of law.
You have a point, they have a point also. But it is a question of interpretation now. If Supreme Court says that on the same day, if interest and dues orders pass on a same show cause, same inquiry.
No, Supreme Court has not said that.
I'm saying if suppose it holds.
Matter ends.
Matter ends.
Supreme Court has used the word, composite word, one facet of the order. My lord, you will take note. I will take there, your lordship. One facet means one part of the order is appealable and one part is not.
So in a composite order, naturally it will come like that.
That is. But here it is separate order. Separate order. And my lord, single bench, my lord, exactly given this, if it is a common show cause, same proceeding, then why it should not be treated as common? That has been stated by the division bench. Because
that'll be subject to interpretation again.
Yes, man.
Because we can't have one foot on one boat and the other foot in the other boat.
No.
Then what will be the situation? Can you elect to select a forum? Either you come to the
no, I cannot.
Orders or whether
but because of the peculiar situation. Yes, because of the peculiar situation. Let her make the submission. I will try to satisfy your lordships.
Right to appeal
is creation, my lord. That only the legislature they can lay down, my lord. Court cannot. That's what, my lord, the thrust is on this. If I can take my lord to High Court engineering, there's it is a creature.
I think you rely on it because it says that my lord, is
appeal
must be under authority of law.
Exactly, exactly. It should be provided in the statute. Court cannot create one. But what happens if there is a composite order? No, meaning of the composite order, my lord, I think very clear in High Court engineering. And single bench of my lord Delhi, perhaps my lord misinterpreted, and that is the reason my lord is stayed by the division bench. And matter is next fixed on March 19th.
Lordship, even I have relied one more judgment is that from the Delhi Bar Associations, they have filed one more petition regarding, I think it is there or there with Lordship. I have...
No, there's some judgments here. That is...
Ashish, that I have one copy, only one extra copy, Lordship.
This one versus Honoris Secretary.
Lordship, Delhi Bar Association.
19/10/2023.
Yes, Lordship.
What does it say?
Here, limited prayer of the petitioner, Lordship, to issue writ of certiorari or mandamus to or any other appropriate writ, order or direction to
decide on 7Q and 14B together.
7Q and 14B.
As composite order.
Direction
what happened to this?
CGIT. It is also pending, but it is here they have prayed to send the matter for CGIT. I am also saying that let this matter go to CGIT because their Lordship it has to be dealt through evidences, Lordship. Unless and until tribunal tries, the evidences is examined.
Okay, there's an LPA.
Even in Delhi, they have taken note of this. So they have not proceeded further.
The prayer of that also is to go to CJIT. So if I am also praying, let it go to CJIT because we need to examine take into account.
What does Rajiv Gandhi Cancer Institute say?
Rajiv Gandhi same with Gaurav, same line, but it is not appealed, Rajiv Gandhi's.
Other than, my lord, in fact, one case is pending now, my lord, that NAT India similar issue is involved.
Whether things, see, one thing, we have to look at, I don't know, maybe we can generate judgment, whether these two orders can be categorically defined or decided to be independent of each other. Can that be a stand? Can that be a finding? That are they independent of each other? Can that finally be arrived at? It comes the same show cause, same inquiry.
Exactly.
Only that on 7Q, 14B, two orders are passed.
Exactly. Then they are not composite. If they are not composite, but they are separate.
Whether they are independent of each other.
No.
That's for you to show that they are independent of each other.
No, my lord. Interpretation has been, ratio has been laid down in High Court engineering. And High Court engineering, they're saying has to be a composite order. Has to be a composite order. The language used, one facet of the order, they have said one facet of the order appealable, other facet is not.
Right.
That is the ratio laid down. So my whole endeavor, my lord.
Your whole case is only that appeals have been provided.
Lordship.
Appeal a creature of statute.
Lordship.
No one has the authority just to file an appeal.
Lordship.
And so it's not composite, order is not appealable.
Lordship.
And that the orders are not composite, it's not composite.
Lordship.
But are they independent of each other?
Yes, my lord. My humble submission, yes.
Yes. But the same proceeding.
Same proceeding. But they are not composite. No, either they can be composite or they can be independent.
Can we take that passing of a single show cause will make the order pass, whatever it may be in 1 or 2, 3 orders, a composite order.
My lord, my humble submission, no.
If it's one show cause,
my lord,
one inquiry.
My lord, there is altogether a different meaning of composite order. If you look into the language of High Court engineering, otherwise they would not have said one facet of the order, one part of the order. They are not saying, my lord, the same proceeding.
No,
this is the interpretation.
But if the courts are feeling a practical difficulty,
lordship,
that a person can't put his feet on two boats at the same time.
My lord, what I will submit, my lord, at this stage, so far, my lord, this is what is in my lord's mind. A similar thing was in the mind of the single judge at Delhi, your lordship. So why not? We can treat it as a composite order, relying on the ratio.
Common sense. How can they be independent of each other? They might on the same day 2 orders were passed, one on 7Q, one on 14Q, one appealable, one not.
My lord.
And so,
my lord, My lord, but the court has said.
Can't the CIT look at it and say, okay, fine, that part they can?
No, the other thing, your lordship will look into it. My lord will appreciate. I am in a writ court before the writ court. Now, separate order in the same proceeding is not a composite order. That is not only my stand. That is the stand of the Provident Fund before the Delhi High Court. And that LPA was preferred, my lord. When the single bench has treated, no, it's a composite order. Who was aggrieved? Provident Fund was aggrieved. And they have preferred this LPA. Now, can they take two different stands, one here before the Meghalaya High Court, one before the Delhi High Court?
Lordship,
that is wrong.
Lordship, the LPA was filed. We do not know exactly what was seeking, because had there been LPA based on that,
there's no uniform process or uniformity in your organization with regard to
Lordship, had it been
points of law.
Lordship, had it been so, Rajiv Gandhi would have also been challenged. Why only Gaurav Enterprise is challenged?
You get instructions why Gaurav is challenged? Because it's one very difficult to decide.
They only, man, they raise this issue seriously. They have gone for a LPA.
Who draw the LPA? Who Delhi High Court?
This will lead
but that's a contrary stand you're taking here. If you're seeking to maintain the stand that you're stating, you're submitting now, that means Gaurav is good for you, right?
Yes, Lordship, Gaurav and Rajiv Gandhi.
He is good for you. Then why do you appeal against Gaurav?
Lordship, I have to find out. But Lordship, had it been so that challenging,
we're not going to look at things that we don't know about. What happened inside your offices, we don't know. But a simple thing. If the court can declare the independent of each other, or they can show, then fine. Then there's no question of it being a composite order.
In Gaurav Enterprise,
but if the facts and the circumstances are such that common sense says that it's the same inquiry, same show cause, only that two orders of passed, one interest and one dues payable, then
Gaurav Enterprise, my lord, their submission of this thing, Provident Fund, has been recorded. The same submission I am adopting, they have adopted. The same proceeding, it can't be treated. Now, how they can take in different High Court, my lord, creating so much confusion?
So what do we do? Yes.
Lordship, I just take instruction on Gaurav, because as per my knowledge, Gaurav has not been challenged on that ground, Lordship, what my learned senior is mentioning. But had it been so,
at least bring it to our knowledge also.
Lordship.
Their submission has been recorded.
On hearing the counsel, no, right, MSP Saji today praised that she will have to obtain further instructions on the grounds as to why. I don't know, instructions with regard to from whom?
From Regional Provident Fund Commissioner only.
No, we will record that. He is going to say just after 2 weeks we will finish.
There is an interim order. This is the reason, my lord, whenever I file one, I make Ministry of Labor a party. But my learned friend is even opposite. Labor should not be a party. They should know what is happening, my lord. They are taking one stand here, another stand in Delhi.
At 3?
Yes.
Please, Your Lordship. Your Lordship, I am praying for some time to file my rejoinder, my lord. Can be fixed, the matter can be fixed.
Already filed.
Rejoinder to what?
They have filed an affidavit, my lord.
Short rejoinder you wanted last time?
My lord.
Yes, as prayed for the 2 weeks time out for rejoinder affidavit. Yes, after 2 weeks.
39.
Lordship, I'm appealing for item 36, Your Lordship. And Your Lordship, we also would like to file our
report 36, Mr. Robme and 36, and who else? Mr.
Interim order is there, my lord. Well, the only thing is,
but
Dingdo has
senior counsel has submitted last time that
there's some urgency, Lordship.
Some urgency, but you're coming up with some document or some policy decision with regard to sanction posts, working sanction, whatever.
We've already filed.
No, that I mean whether the council is coming with some certain other measures. When can you fix it? We'll finish
next week, Lordship.
Next week,
Tuesday.
Can you file it within Tuesday? Tuesday 17th.
17, 18, my lord. File it by that time.
We'll fix it, yes, up to now it's the 9th, now it's the 10th.
10 lordship.
We'll have on 23rd.
My lord, some difficulty on 23rd, my lord.
Then
I'll
18th.
be out of station. 18.
18th.
18.
I do oblige.
How many are pending cases? You are appearing in how many cases?
He's appearing for one case, man.
And the
I'm
others?
appearing 3 for the rest. I'm appearing, man.
36 in total lordship. 36 in total. I do oblige.
39.
My lord, pleadings are completed, my lord. Matter can be fixed for hearing, my lord. Yes, my lord.
Contempt, you are hearing. We dispose of now. What's you ready?
Yes, my lord. Yeah,
You ready?
sit for hearing, my lord.
Okay, this for you after 2 weeks. Yes.
Oblige. Oblige.
40.
May it please, Lordship. Lordship, this is a pension matter, Lordship, and respondents are yet to file the affidavit. Lordship. Petitioner is working in the agriculture department.
Where's the government advocate? They won't file affidavit till date.
Not yet, Lordship.
When does this matter file? When did the petitioner retire?
He retired since 2019.
Are you appearing here? No.
No, Your Lordship. I will seek instructions, Your Lordship.
What about this approval, initial pay statement, so on and so forth?
Lordship, here are praise for pension benefits, Lordship.
What was this letter last time? This letter dated 4th December
That
2025.
is with respect to IPS, Lordship.
Have you signed the documents?
Not yet, Lordship.
Then?
Lordship, because here the main grievance of the writ petitioner is with respect to his pension, Lordship. That IPS, Lordship, is a different aspect.
Who's the government advocate here?
Your Lordship, as per the last order, Mr. A.M. Pala was appearing. I'll take instructions, Your Lordship. I'm praying for some time today.
He retired in 2019.
2019 also.
Who's the officer concerned? We'll ask for his appearance then.
Your Lordship,
Matter
I'll
will be
give
filed
us...
till July 25.
Your Lordship, I'm praying for 2 weeks' time. We'll ensure that the affidavit is filed before the
Whatever
next
it
day.
is, we can't be left unattended like this. If a person not got his pension from 2019, how do you survive? He was working as
an inspector of agriculture, or horticulture inspector.
Mr. A. Movement appearing before. Then Karwan Lang. Then Mr. Pala, it seems, been appearing from September. Where is he?
He's not here, Your Lordship.
We can see that he's not here. Otherwise, see, we'll have to be constrained to call whoever that is. Let them bring the records, we'll settle it here only. You need affidavit also. Can't leave pension matters like this.
Your Lordship, give us 2 weeks' time, Your Lordship. We'll ensure that the affidavit is filed on the next day.
The designated government advocate for the matter is not available today. From MSZ in our country, GA submits praise that he has no instructions, but that 2 weeks be given to enable her to obtain the same to file affidavit. You conduct this case henceforth. If they're not interested, they'll consult the director also to. Where's the brief that directed to ensure that positive steps are taken and that she also appear in this matter henceforth. Yes. You should sack those people if you do not.
What do you want?
Authorised.
My lord, with respect to the status report, my lord, there is a slight delay on acquiring from the Nongtleo post office. That's why we haven't produced before, my lord.
Yes, sir. What's the matter about?
My lord, this is for seniority, my lord.
My lords,
You file affidavit?
No, my lords. One
Why?
week time. 1 week's time, my lords.
1 week's time.
Yes,
It's
my
a
lords.
matter.
My lord, herein I was already an additional SD SEO.
Okay.
Yes, my lord. Whereas my juniors has already been promoted, but my name has not been reflected in the latest
The
seniority
High
list, my
level
lord.
council, the petition submits that status yet to be received on service.
Respondent number 15.
Also with regard to respondent number 15. Stop. MSS Sham Legal Counsel for the
Respondents 1 to 3.
respondent. Praise for the to stand to file affidavit. Yes. Just after 2 weeks
Grateful, my lords.
for the orders.
42.
Wait, please, my lords.
Yeah.
Much permission to appear through the VC, my lords. I'm appearing for the petition in this matter, my lords. But the pleadings were already complete on the last date, my lords. On the last date, the respondents had taken time to file additional affidavit. Nothing has come on record. Just
When
one
was
thing,
the
my lords,
last
I
date?
want-
It was 1 week ago. Yes.
Lordship, we've not been able to receive instructions as from the concerned branch. They've sent to Delhi, the headquarter, Lordship. But Dr. Muzika
I just need to
Lordship, he'll be in a better
fact.
position to answer.
1 second,
queries,
Mr.
Lordship.
Gupta. Wait.
Yes, yes.
Dr. Muzika is
We'll
coming,
take it after some
Lordship.
time. Dr. Mosika is not here right now.
Very well, my lords. Very well. I'll await, my lords.
43.
We are taking steps to the respondents. These are MSL respondents, Lordship. I am praying for some more time to ascertain the status of service from the postal department.
Me same prayer I made last time.
Lordship, yes, I have not able to get the confirmation report, Lordship. But these are otherwise MECL, Lordship.
Go and serve in the office and get endorsement.
Very well, Lordship. I maybe.
Yes, Mr. Yes, better. Mr.
But of course, in July, this is MEPDCL
This is
July,
July.
Lordship. Yes.
So what's the hardship? The petitioner from where?
Petition is also from July side. Clear.
Mr. S. Devna, consul petitioner, submits praise I will have to effect personal notice, personal service on the respondents 4 and 5.
And file an affidavit.
Yes, and file affidavit. Praise allowed this up to 2 weeks.
I'm pleased.
44.
May it please your lordship. Lordship, I'm praying for some time, your lordship, to file our affidavit.
What's the matter about?
Your Lordship, this is in respect to erection of a concrete signboard by the Forest Department, Your Lordship.
Concrete signboard?
Concrete signboard, yes, Lordship.
Your lordship, they had alleged that the forest department has encroached their land, your lordship.
Some dumping of concrete.
Dumping of what? Concrete signboard
Erection of a concrete signboard, Your Lordship.
and dumping of concrete is two different things.
That is what they say, that they have encroached and dumped concrete in their
Which
Aking
is
land.
within the account of the petitioner, Your Lordship.
Here for response number
I'm for
5.
5.
If 1 to 4.
1 to 4, your
MS
lordship.
Ilingwa for 1 to 4 is there for 5 pre-allowed for the 2 week time to file affidavit. This thereafter and so on. So.
45.
Much obliged, lordship.
Please, Your Lordship, I'm VC counsel for the petitioner counsel. Your Lordship, in this case, there's a direction for issue notice to respondent number 3, 4, 5. So it's completed. And there's a direction for area GHDC as party as respondent. we pray more time to.
Have you pleaded the GCDC?
We have not yet.
That was last year you prayed.
Yes.
You've taken steps on 4 and 5.
We have taken steps.
You've received.
We have received.
The accused Rango Leonard Council Petition Service that status of service respondent 4 and 5 is yet to be obtained. He pays funds allowed to obtain status stub. Further submission is that permission for further is for
RAHHC as party respondent.
The purpose that they should be allowed further time to put in an appropriate application for impeding GCDC. Praise allowed yes after 2 weeks.
Second call. Supplementary list 1.
This is an application under Section 11 for appointment of an arbitrator. Whereas the petitioners in the business of manufacturing passenger lifts and escalators. It was awarded a tender for installation of passenger lifts at the Indian Institute of Management in Shillong. The initial completion date was 2018, but there was a delay which according to us is attributable to the respondents. Ultimately, 2018. It was completed in 2021. This is an admitted position. Now, during the stage of clearance of bills in 2025, as late as 2025, the chief engineer of the department issues a show cause notice proposing to levy a penalty for the delayed completion of the work. We responded to this, and thereafter he's imposed a penalty about 11 point something lakhs in 2025. A dispute having arisen, we've issued a notice under Section 21 for reference of the disputes to arbitration. Since they've not acted on this,
When was the letter sent?
Well, the letter has been sent 29/10/25, October 25, at page 41. This is the formal notice under Section 21. And in fact, thereafter, on the 14th of November, they've credited an amount of about 2,80,000 rupees unilaterally. That's not the claim amount. There is still a due about 15.5 lakhs.
How much does the lift cost?
The total value of the work was above 1 crore. It's 1 crore.
Four lifts.
Yes.
Now, yes,
Estimated cost was
regard to one lift. Or disputes regarding all the
payment for the entire work.
Outstanding payment.
Delayed completion of the work.
No, outstanding payment you claim.
My lord.
And now they are contesting on the ground of delayed completion.
Yes.
Which will levy a penalty on you.
Yes, my lord. So whatever was my due, they've imposed the penalty and withheld that amount of penalty.
Then send for arbitration, Dr. Mazga, what is there?
Well, the difficulty, Lord, so kindly see page 41, my lord. They're not asking for appointing an arbitrator. Kindly see, my lord.
See, above referred reply, so to appoint after not hold good.
Last paragraph. Therefore, you are called upon to pay 19 lakhs along with interest. Date of default and so. Failing which we shall approach the honorable. He is not asking us to appoint.
No, my lord. I'll explain why. Please see the clause. Please see the clause. I'll tell you why. The clause is now redundant, the arbitration clause, in view of the amendments to the Arbitration Act. Originally, a department could make the appointment as far as an in-house person is concerned from their own panel. In view of the amendment of Section 12, subsection 5, now they are ineligible. In fact, the power of appointment of the arbitrator, as per the clause, is invested with the chief engineer. Now, by the decision of the Honorable Supreme Court in Perkins, he is also ineligible, consequently, to make the appointment. So we have adverted to the decision of Perkins and pointed out that you are no longer eligible to make the appointment. Now they still contest and they insist that we still have the power to make the appointment. I'll place that judgment for law.
Perkins says that only you have an interest in the outcome. Then you're eligible to appoint arbitrator.
So they are in-house. They are members of this particular department. The chief engineer is a serving officer of the department. So he cannot make the appointment.
They propose whose name is arbitrator?
The lordships will decide then. He cannot make it.
Have they proposed?
No, they have not proposed.
Then
they are not even approached me properly for appointment of arbitrator.
Then you file in a proper letter.
Yes, ma'am.
Communication to them to put up matters
let me then fix a date for hearing. I'll place the judgments of the Honorable Supreme Court. I'll satisfy my lords. It's not required anymore.
My lord,
He is ineligible.
Another aspect, my lord, Perkins' judgment is 2020, my lord. In 23, between the same department, same contractors, same CPWD, my lord, they ask us to appoint an arbitrator. They don't raise all these objections in that point of time, my lord. In 23, my lord.
I don't think that will prevent us from raising this objection now. It's a point of law. That does not prevent us. I'll satisfy my lords on this
But I
point.
think a point of law should not also disable, like, speedy, like, resolution of dispute.
Correct.
That's all. The law is not meant to create obstacles. Is meant to.
Lordship, I understand.
Yeah.
I'm saying, my lords, that this 25 is now redundant. They cannot make the appointment in view of the
So
decision.
we can
of the
overlook that. Appoint arbitrator. We'll appoint arbitrator, and the amount very small.
Lordships will appoint the arbitrator. I have no difficulty with that.
We take instructions.
No, that's my instruction. My lord. They should write a
Yes,
proper
but Mr.
application for appointment of arbitrator.
The petitioner, Dr. N. Musica, then it ESGI with MS
Chala.
Yes.
The sole respondent.
Present, we have the sole respondent. No further notice required. So, the prayer with petitioner is for appointment of a sole arbitrator to adjudicate and decide a dispute between the parties in terms of section 1 of section 12 of the Arbitration Function Act 1996. So, if Mr. S. submits that this court will approach directly in view of the amendment which has been caused to section 12, which disallows the appointment of an arbitrator from the department itself or interested party. Next stop. Dr. N. Musica, in reply, has submitted that there has been no formal request till date with regard to putting up the dispute for arbitration, and submits on instruction that if the writ petitioner so desires, a formal request will be officially considered. However, to this submission, Mr. S.N. prays that matter will be for admission hearing.
Lodge.
If that is the entire clause 24 will go. There is no arbitration clause then.
Yes. It won't. I'll satisfy Lodge. It won't go.
Just after 2 weeks, yes.
Lodge. I'll oblige.
Item number 5.
My lord, the letter pertaining to recruitment of Constable ZD. My lord, there was an advertisement, my lord, that is at page number 10.
Number 10.
Page number 10, my lord. And it's
for constable.
Yes, my lord. Constable ZD.
This is for. Is it a common recruitment for all?
Nowadays, common.
CAPFs.
My lord, is conducted by Staff Selection Commission nowadays. My lord. Earlier, every paramilitary force used to do separately. My lord.
Now it's gone since when?
Since 4, 5, 6 years, my lord. Since 20 or.
Yes, my lord.
So now CRP, Assam Rifles, BSF, all common recruitment.
Common recruitment. Only they have to give a choice. If they have any particular preference, like civil service exam, in the particular preference they want to go to Assam Rifle, they have to give preference.
Yes. My lord, there was in response to this advertisement, my lord, the petitioner has applied for the post, and thereafter, my lord, he has received the admit card to appear for the examination. That is at page number 40, my lord.
Okay, what happened after that?
And he has cleared the examination also, my lord. My lord, may kindly see page number 41.
Okay.
He has cleared the examination, and thereafter, my lord, he was sent for PET, physical efficiency test, and physical standard test, my lord. That is also he has cleared, my lord. Next, and after he has cleared, my lord, he has been sent for detailed medical examinations and DV. That was also done.
He's cleared all that.
He has cleared all the examinations, my lord. What has happened is they have taken out a list that is at page number 53, Annexure 10, my lord. That is the debarred, rejected candidate and cancelled candidates. His name is not there in that list. These are the candidates whose candidature has been debarred, rejected. However, his name has been reflected in Annexure 9, that is at page number 50, my lord. That is the withheld list.
What is there against you?
There is no reason, my lord. Around 2003 persons' name has been withheld, and similar cases. 2003. And from Meghalaya, he is the only candidate, my lord, who has come before this court. Similar incidents, my lord, it happened earlier also. That is,
take notice.
Yes, my lord.
Mr. and secondary counsel of the petitioner has issued notice of the Mozika with MSc Jala as present behalf of the respondent. No further notice called for. Just after 2 weeks. 3 weeks, okay, for instructions of affidavit. Yes. If he's qualified, there must be some reason.
Result, that's all, my lord.
When the instructions will come out.
Yes.
Item number 6.
Yes.
ACR matter, non-communication of ACR matter. I'll have
my lord,
but the dates will be recorded.
lordship.
For next date, I'll have instructions.
Yes,
My lord, my prayer before
issue
the
notice. Yes. Yes. We'll dispose of this. Is a covered case.
ACR are up to date, my lord. The ACR for the period of ERE duty, that has not been taken into account, my lord. My lord has disposed of the similar matter, my lord, that I have annexed at annexure 4, page 22, my lord.
Let him take instructions.
My lord.
Formality, yes. Yes,
my lord, my lord.
I heard Mr. V. Kumar, legal counsel of the petitioner, with MSPG3.
Yes, Lord.
Yes. We should write local counsel or no? Okay, just say to it so and so. Yes, Dr. N. Wazika, Leonard GHI with MS Sijaraj on behalf of all the respondents.
Yes,
no further notice called for. Just matter of 2 weeks for instructions or affidavit.
Deeply, your lordship.
42.
Wait, please, my lords.
Yes.
But the only thing which I would want your lordships to consider, my lords, and then I will leave it to your lordships, whatever your lordships deems appropriate. What's the DPC in this case? What's the DPC in this case was held on 10th of December. Your lordships had posted this matter for hearing on 5th December. With the assurance that the counter will be on record. This has not been apprised in the counter affidavit. That's the first thing. 2, my lords, my writ petition is filed only on the apprehension that my promotion will be disturbed, I will be harmed, and that has been done. DPC is already gone. Despite your lordship's order of quashing the charge sheet in the earlier writ petition, in the DPC they have adopted sealed cover approach on the basis of the charge sheet which has already stood quashed. But in this very case, para 39 of the counter affidavit, my lords, they have said that what they did in the charge sheet is correct.
Even after being quashed.
Even after being quashed. Para 39 of the counter affidavit, my lords. But my apprehension that they want to damage my service, my promotion is being proved before the Honorable Court time and again, my lords. And I'm only, my lords, requesting if this could be heard, my lords. The pleadings are complete, just like, my lords, in the first writ petition. The way respondents took time to file corrigendum, which was never filed. Similarly, my lords, in this case, the additional affidavit is sought to be filed. They took, my lords, 3 days to file counter affidavit, despite the urgency which was already there before the Honorable Court.
Now, Mozika, what additional documents you want to file?
What additional document we wanted to file a sir rejoinder to the rejoinder, my lord.
No, but then why is not on record as yet?
Because on the last day,
lordship
ordered to file a proper application for that, my lord.
No.
So when
the last order says that you took permission to file additional documents, correct? Yes.
But it is for the respondents they wanted to file, my lords.
Then you file your affidavit then. Because actually, sir rejoinder also is not by right, you understand? That's why
that's what
yes, my lord. There will be a reason as to why we'll permit you to bring the additional documents.
So, my lord, we will file an application, my lord. So, kindly grant a week or 10 days time, my lord.
Will there be posted for hearing?
My lord.
Lords, just one request. Lords, I have no difficulty. Just one request. Lords, the DPC is held. ACC is being conducted.
Fine. We will look into that, Mr. Gupta. Yes.
Lords, may post it for final arguments. That is my only request.
Today also the petition additional affidavit on behalf of respondents to bring on record actual documents or application or affidavit of the respondents to bring on additional documents that have been filed. Stop, Mr. N.K. Gupta, then counsel petitioner, please a matter be listed for hearing. In the meanwhile, yes, hearing, stop. When should you post it? Post it on 23rd of? Why is auspicious day? Yes, 23rd.
Once I have requested my friend to request for 23rd February.
23rd, okay. Also 23rd for hearing.
But that will
be filed in the
sufficient
meanwhile.
time for respondents also.
Yes.
That's for hearing on 23rd.
Yes,
I'm so
23rd.
obliged.
Hearing 47.
I'm so obliged. Obliged, Malak.
Yes.
Me, please, Your Lordship. Lordship, senior counsel is still on legs before court one.
You start. What is there?
Lordship,
Let junior counsel take the charge or take the lead. Yes.
I'm not the briefing counsel in this matter, Your Lordship.
Who the briefing counsel?
Mr. Chanda is on legs along with.
Briefing counsel is on legs. Even the senior counsel is on legs.
Yes, Your Lordship.
Who the pin other side?
Lordship, electricity corporation, Your Lordship.
Where's MECL? Where's MSR Kolni? He's not in court.
She's there, Your Lordship.
What's wrong with that? This matter was supposed to settle. What happened?
Lordship, I don't have the instruction, Your Lordship.
Your Lordship, Miss Kohli is also on legs in court number 1.
As the counsel partner revealed this after 1 week, yes.
50.
Look, this matter was heard at length. On 12th of November. This is that matter, my lord, where this petitioner has been superseded, my lord, by his juniors in view of 2 criminal cases being pending against him and 2 DP.
What happened to, where's Mr. Shulai? He's on legs also?
He's on legs, Your Lordship.
How many lawyers are on legs in?
My lord,
The matter come at the end of the board, Your Lordship.
Lord, as far as the DP is concerned, my lord, both the
What happened to the criminal cases?
criminal cases, my lord, one case, my lord, trial is going on, my lord. This is the last order.
Stage?
Dated 2nd of February 2026. It appears that some of the accused are yet to appear, my lord. Though it's fixed for evidence. Witness was not present.
Fixed on 16/3/17/3.
So this has been going on for a long time, my lord.
23.
No, my lord.
Sessions case 23.
Yes, my lord. Sessions case is after the charges are framed. Prior to that, my lord. And as far as the DP is concerned, my lord, the last date.
What happened to DP?
DP, my lord, last date was May 2025. So both the DPs are being conducted my lord, simultaneously.
Yes, should I?
Sorry, Your Lord. Lordship, kindly have this matter next week, Lordship, Monday or Tuesday.
No, only last time we wanted to know what
Lordship,
the exact
yes.
status of the
Because what happened, Your Lord,
exact status of
Lordship,
the-
Mr. Khain is not available today and tomorrow, Your Lordship. Kindly have on Monday, Your Lordship. Monday or Tuesday, Your Lordship.
Oh, the status is here, the order sheets are here, not.
He's obtained the status already. Sheets. Or assistant counsel is Mr. Khan.
Lordship, yes.
Yes.
Kindly have on Monday, Your Lordship.
Monday is 16.
Monday 16, Your Lordship, yes. Then 17.
17.
17 also will be.
Yes, Mr. P. Nombri today has produced the status with regard to the criminal case as also the department proceedings pending against the writ petitioner. However, in the July, praise that more conviction will be given unless the matter next week, yes.
Lordship. Highly applied.
52.
Yes.
Please, Lordship, I beg for interference for the respondent number 4. I'm sorry for the delayed appearance, Lordship.
But Your Lordship, kindly, there is order dated 22/5/25 and 12/6/25. Already expiry
I understand, Lordship, but
22/5/25.
at this stage I am not praying for any recall of that. Why, Lordship, if Lordship could see the petition?
How are you going to make submissions then?
Lordship, I am not trying to wind.
You can make submissions.
Wind back
fine.
the clock. Only what I wanted to point out, Lordship, after getting the petition, if Lordship would kindly come to page 11 of the writ petition. Because for us to take instruction, if Lordship would see page 11, paragraph 12, Lordship.
Yes.
I may very quickly read it, Lordship. That the petitioner begs to submit that he is the senior most assistant teacher in the school and his due date for superannuation is such and such. Presently, the petitioner has been pursuing B.Ed through correspondence with due permission from the authority, but without considering the above mentioned facts and circumstances. The school managing committee illegally adopted a resolution in the meeting dated 27/2/25, thereby decided to promote the respondent 5 to the post of assistant headmaster of so-and-so school and deprive the petitioner. This resolution is also not found in the petition. It is not under challenge, Lordship. And kindly see at the next page, paragraph 15. In the next paragraph, he says, Lordship, that the post is lying vacant.
It's lying vacant.
No, Your Lordship, respondent number 6 has already been appointed.
What
His
has
approval.
happened is there is a resolution. Resolution has been
You're for number 6.
Yes, may it please, Your Lordship. I am entered appealing today for responding.
What is this? This case come to hearing stage and people entering an appearance.
Everybody is appearing.
Already expected that as long back.
Yes.
12/6/2025.
One second. Even then, you have to stand on your own facts. I mean, on your own merits also. If your case does not, 4 is a management committee. 5, you're the present assistant headmaster.
Assistant headmaster, Your Lordship.
This has been already approved by the government.
And he's
before
been appointed
filing his
also.
writ petition. Before filing of the writ.
Then you have to file fresh.
And resolution and his prayer is just to promote
After filing this, when the affidavit is filed by the government, then we have come to know that it is approved. Because we
He mentions the resolution, Lordship, in his paragraph.
Where, yes. Where's the resolution?
That has not been
It's not
attached.
there in his-
It has not been
in
attached.
opposition, filed by the government, it is there, Your Lordship.
Yes, but then you have to put in a challenge. You can't rely on their materials to support your case to say that it's there in the affidavit. Mr. E. Ahmed, correct?
Yes, Islam.
Oh, Islam, sorry.
Islam.
Yes. What do you want to do?
Let this matter be kept.
Well,
Already matter is hearing. I file a fresh.
You file a free withdrawal and file a fresh. Otherwise, it's incapacitated.
I would pray, Lordship, if he wants to pursue, then I'd file an application. Kindly grant leave to file an application for recall of the expert.
You have to be heard because we are the most, what you call it, the answering respondents. You file an application. Yes, when is the order of ex parte hearing pass?
12/6/2025.
12/6/25.
And earlier.
When do you receive notice? You pay cost.
Because we have just got the brief
22
No, I'm not saying you pay costs. I'm saying your respondent pays costs for restoration.
22/5/25 as just observation of this court that if next date is not appeared by the respondent, then court will pass expiry order. Then next day 12/6 that order pass. At first 22/5/25 your lordship. There is lordship's observation.
Yes. Though orders for ex parte hearing against respondents 4 and 5 have been passed on 12/6/2025 and the matter has proceeded stop. Today, Mr. S. Deb, Learned Counsel, has under appearance has appeared on behalf of number 4. And what's your name? What's your name? Your name?
Martian.
Miss. Your full name?
Yes, Martian.
That's your title?
Yes, Nayang.
Nalyang.
Nayang, Lordship.
Nayang. Your first initial?
M.
M.
You're Mr. Deb Jr. Okay. Yes, sir. Come. And M. Nayang on behalf of number 5. Stop. They pray that as they are the main answering respondents, they may be allowed to put in an application for setting aside the ex parte order of hearing and to allow them to participate in the proceedings. Stop. This court on the prayer made by the Learned Counsel has noted that in spite of it was never recorded whether it is served or not.
The matter came up on 20.
No, when did you file service affidavit?
The next date only it was.
Did you file an affidavit showing service?
I don't think he has filed.
I think file your lordship.
Didn't file.
Already file your lordship.
Affidavit indicating service on 4 and 5.
4 and 5, I think file.
No, from the office noting, it does not appear that it's been recorded. Anyway, for the ends of justice, the prayer of the Learned Counsel is allowed. Application be filed within
1 week.
1 week, yes. The list after 2 weeks, yes.
Pleasure.
53.
My lord, Mr. V. Kumar is on legs, my lord. Kindly adjourn the matter for today, my lord.
The matter was heard. He was supposed to place some judgments on it.
No, he's on legs. And he looks as if he's not ready by looking at his face. He's not ready with the matter.
I'm not ready, my lord. When I will carry out the fact, my lord.
Right, take down on the request of something on behalf of Mr. V. Kumar, map or something. This after 1 week or 2 weeks. Yes.
54.
Please, Your Lordship, I appear for the petitioner in this matter.
Yes.
Please, Your Lordship, I have applied for the post of Havaldar Clerk in Assam Rifles for the state of Maharashtra. I had successfully qualified in the selection process, but subsequently my candidature was rejected. If Your Lordship would have annexed your R8.
Page?
Please, Your Lordship, the reason for page 68 of the counter affidavit.
Page?
68.
68, Your Lordship. 68. 68.
68?
Of the repetition.
Yes, Your Lordship. Annexed your
Repetition.
R8. Please, Your Lordship, the reason for rejection is that there was
So one thing,
FIR
MS
pending.
Lamba, there's a lot of white light coming from behind you. It's causing a bit of disturbance. I mean, your
Please,
will.
Your Lordship.
Something.
Please, Your Lordship, I'll sort this out.
Just
Please,
sort
Your
it out,
Lordship,
please.
just give me 1 second.
Yes.
Please, Your Lordship would now have page 68. The reason was rejection was that there was an FIR registered against me. Please, Your Lordship will see paragraph 3 is where reference to that FIR is made.
Yes.
Please, Your Lordship, today I am relying upon judgments to show that mere registration of an FIR cannot be a ground to deny me appointment.
Yes.
Please, Your Lordship would have my judgments. Please, Your Lordship would have my compilation. The first judgment is of Delhi High Court.
Yes.
Please, Your Lordship will see paragraph 3.
Yes.
In the present case, as has been noted in our order dated so-and-so, the criminal case has arisen out of a matrimonial dispute between the petitioner and his wife. The proceedings in the said criminal case have been stayed by the High Court of Judicature, Allahabad, by the its order dated so-and-so.
Okay. Next one.
The petitioner cannot be made to suffer.
Yes. Yes.
Yes. Please, Your Lordship. Yes, the petitioner cannot be made to suffer a punishment when the criminal case is yet to be adjudicated. We do not need to emphasize that in the matters of public employment, the opportunity does not come repeatedly and may never come for the petitioner again. The petitioner has been successful in obtaining the employment with the CISF based on his own merit and qualification. In case the petitioner is not allowed to join subject to pendency of the criminal case, the petitioner may lose this opportunity for all times to come, and this loss would never be compensated. On the other hand, in case he is eventually found guilty, the balance can be struck by making his appointment subject to the outcome of criminal case, and in that event, directing that he would be terminated from service without any notice or following the rigors of an inquiry. Please, the Lordship would have paragraph 7 of this judgment. By the Public Service Commission just because he was implicated in a criminal case, the result of which may either be conviction or acquittal, is certainly denial of his opportunity to enter in service when chances of getting employment is now a nightmare due to the risk of tough competition. If at last the victim is honorably acquitted, he will be languishing, losing his hard-earned chance of employment. If this is encouraged, naturally one who has enmity towards a person can destroy his future by implicating him in criminal offence, as politically motivated gang atrocities are not rare in this state. In such situation, the police in their FIR gives a vague report as so-and-so and 30 or 40 others. This can be conveniently filed with any name according to the whims and fancies of the investigation officer. The victim in the present case may be one such person whose destiny is in the doldrums. Ultimately, after training, if he is found guilty, the petitioner can be dealt with as per law.
Yes.
And Your Lordship will now have my third judgment. That's also again of Kerala High Court. Please, Your Lordship would have, this is a long judgment. Your Lordship would have page 26 of my compilation. Please, Your Lordship, after a thorough discussion, if Your Lordship would have page 27, paragraph where paragraph 8.
No, we understand you, but then what is the nature of the offences against the petitioner?
ST.
Yes. And Your Lordship, just note that this judgment stands upheld by the Supreme Court.
Yes. What were the charges against the petitioner? And what stage the trial?
Yes. Please, Your Lordship. Please,
What stage the trial?
the charges are yet to be framed. We're still at the stage
When
of
was the FIR
charges. They are
filed?
yet to be framed.
Any instructions?
Please, Your Lordship, the FIR is of the year.
Page 13 of my affidavit.
Please, Your Lordship, just give that date.
A typed copy is on the next page, my lord.
Serious charges?
IPC is Civil Caution Civil Trial Prevention of Atrocities Act. Now, my lord, the law in this regard has been settled by Supreme Court, my lord, by a full bench. I'll place the decision, my lord.
Constitution bench?
Full bench, 3-judge bench. The matter was referred to a larger bench and larger bench decided.
Where's the judgment?
I have.
What are the parameters? They look case to case basis.
No, my lord, it's para 32. May I just read, my lord?
Yes.
Para 32 and 33.
MS Lambai, aware of the judgment? Are you aware of the judgment?
Please, Your Lordship, I'm
16-8.
not
SCC.
aware of the judgment.
You note down 2016-8 SCC.
Please, if your my learned friend could tell me the name of the judgment.
Avatar Singh
Did he
versus.
suppress this
Perhaps
fact of
it is
criminal
a
case?
passing.
Did he suppress it?
My lord, that is from the affidavit, that part is not clear, my lord. Because verification of character was sent, my lord, page 11 of Lordship kindly sees my affidavit, my lord.
After selection, verification was sent. Then?
My lord. Verification of character 17th April 24
Yes.
to the Superintendent of Police, Hingoli, Maharashtra. Para 3 board officers observed individual as a suspected case. Hence, it is requested to clarify that somebody so and so can be enrolled in the CF under this above charges as mentioned in the FIR number so and so.
Yes.
And then the reply, my lord, page 12A regarding
Did
the
you name the FIR?
complainant. Yes, my lord, he is number 1 accused. Page 14A, serial number 7, my lord. Suresh Thombare and one more person, Pradyumna.
14A.
14A, my lord. At serial number 7. Suresh Thombare is the petitioner.
Where are you reading from?
Page 14A.
Thombare is the petitioner?
Is the petitioner, my lord.
Sambhaji Suresh Thombare. Oh, same.
Yes, my lord.
What sections are these under the SC Act? Include physical harm or IPC and
SC state.
yes.
Please, in fact, Your Lordship, I'd also annexed the copy of the FIR with my petition.
Yes,
This
yes.
is actually a case that where the
3-1R. Their offence is punishable up to 5 years, my lord.
Yes, so You've seen FIRS. Where is
Please, in fact, Your
judgment?
Lordship,
The judgment is not on the same point, Dr. Mojika.
Para 32 and 33.
33.
And then sums up the law, my lord, in the concluding part.
This talk was fraud misrepresentation. Now, is your case that he has suppressed this fact while submitting his application? Number one. And number two, whether and if he has not, whether then the nature of offences or whether he can be.
Please, in fact, Your Lordship, this was a case where, in fact, the petitioner had a relationship with this girl who was from another caste. And thereafter, her brother had lodged this case against the petitioner and his father.
A false case, I
So
mean.
this,
But the case says that they were in the casualty ward, they're beaten up with sticks or something like that.
please, Your Lordship, but this was offshoot of a love relationship which the petitioner had with the sister of the complainant. And Your Lordship will still appreciate that this is still at the stage of framing of charges. The charges are also yet to be framed. And if Your Lordship would have my third judgment of the Kerala High Court, this in fact stands approved by the Honorable Supreme Court, where the court was of the opinion that mere registration of the criminal case will not enable the government to disqualify a person from becoming member of the service. The SLP against this judgment was dismissed by the Honorable Supreme Court. Please, if Your Lordship would have the last order in this compilation, page 32.
1 second.
Please, Your Lordship will see that this was against the Kerala High Court judgment, and the SLP against this judgment stands dismissed by the Honorable Supreme Court. Please, Your Lordship, would have para 7 at page 34, the special leave petition is dismissed. And if Your Lordship will see that the portion of the Kerala High Court which stands quoted by the Supreme Court also notes that the government could not have concluded that the character is bad to disqualify him from becoming a member of the service without any materials, merely based on.
No, but one thing,
prosecution allegations.
every case stands on its own facts and circumstances.
In my judgment,
In this case, the complainants have turned hostile also. Yes.
Well, para 38.5 of the judgment, my lord, I placed.
38?
38.5, the last page of the judgment, my lord.
This 2016 judgment?
Well.
Yours on a different footing, 30.5 years.
In a case where the employee has made a declaration truthfully of concluded criminal, the employee still has the right to consider antecedent and cannot be compelled to appoint the candidate. In a case when
concluded criminal case.
No, my lord. In a case when fact has been truthfully declared in character verification form regarding pendency trivial in nature, employer in facts and circumstances in its discretion may appoint the candidate subject to decision of such case. In a case where deliberate suppression, well, that will not apply. 38.8, my lord. If criminal case was pending but not known to the candidate at the time of filling the form, still it may have adverse impact on the appointing authority who would take decision after considering the seriousness of the crime. So, my lord, it is not, even if it was declared, my lord, truthfully, it is not clear whether he declared truthfully or not, my lord, in the form. But even if it is.
Your affidavit must be saying that. What's your stand in affidavit?
In the affidavit,
I read Annex
what is their stand? What is
Lordship, their only stand is this, that there was a criminal case pending against me. If your Lordship will see Annexure R8, come back to Annexure R8 again, page 68. Multiple correspondences have been carried out with the Office of the Commissioner of Police, Hingoli, Maharashtra, so and so, to a certain status of legal proceedings in respect of verification of character and antecedents as referred in police clearance certificate deposit during recruitment proceedings. Verification of FIR lodged in respect of Sambhaji Suresh Tumbare has been received from Office of Superintendent of Police, Hingoli, Maharashtra, wherein it has been intimated that FIR number 0214 lodged against the individual under IPC section so and so and SC Act 1989. It proposes your candidature is hereby cancelled in view of policies in respect of character
Okay.
certificate verification.
What's the policy, Dr. Mosika?
Now in para
There have been instances earlier on where candidature has been considered and people appointed.
But here we have said, my lord, the next candidate, the post have been filled up, my lord. In para 10 we have said in the affidavit.
When was this recruitment done?
Please, Lordship, in this case, I had immediately come before your Lordship.
23, my lord.
This relates to the year.
The appointment order was issued on 10/10/23. 10/10/23, the appointment order was issued, my lord.
First round of litigation, because earlier they had not even given me the reason for my rejection. So I had first approached this honorable court, and in that counter affidavit, they had disclosed that this was the reason for cancellation. Please, if your Lordship would have the first, the order, and if your Lordship would have 31st January 2025 order also. So I had taken liberty from your Lordships then.
31st January 2025.
Yes. And if your Lordship will see that my candidature will come back to annexure RA, that's cancelled only on 8th of October 2024. That decision has been taken by them only on 8th of October 2024, which they had placed before your Lordships in the first round of litigation. So nowhere prior to this, they had cancelled my candidature. And this was informed also to me only in the counter affidavit filed in the first round of litigation.
The page 51 is his application, my lord, in the writ petition.
No, he disclosed. They joined it, have said so.
Page 51 of the writ petition, my lord, in his application, what he says, my lord.
No, he says, he has said so. Even in the rejoinder, he has said very clearly that this was disclosed.
He is not disclosed, my lord.
He disclosed.
He is not, my lord. Kindly see page 51, my lord, of the writ petition.
Yes.
This is an application, my lord. Online application.
Any.
Any.
Oh. Ms. Lama, what do you have to say about this?
Yes, if your Lordship will see in my rejoinder,
Rejoinder said during the detailed medical examination.
paragraph 4, that it was I who had placed this FIR before them in my detailed medical examination. And I had filled the declaration form also.
Where's the declaration form?
Yes, please, the Lordship would have 17/4/2024. That has been filed by them. Your Lordship, just give me a moment. I'll show that to your Lordship. Lordship would have page 11 of the counter affidavit. That's a letter of 17th April 2024. Please, Your Lordship, will see paragraph 2 of this letter. It is intimate, and this is their letter. It is intimated that Shri Sambhaji Suresh Thambore, son of so and so, is a resident of village 80, Hingoli district of the state of Maharashtra. Individual has attended Assam Rifles Technical and Tradesmen's Recruitment Ready 2023 against the vacancy allotted to Maharashtra state and submitted under mentioned documents. FIR number 0214 dated 31st May 2022. So I had never concealed this because I was the one who had in fact produced it before them. Boards of Officer has observed individual as a suspected case. Hence, it is requested to clarify that Sambhaji Suresh Thambore so-and-so can be enrolled in the CAPF under the above charges as mentioned in the FIR number 0214 dated 31st May 2022.
Yes, Dr. Mojika.
Now, my lord, application I pointed out, my lord. In application, he says not applicable.
No, but here,
Can you see application is dated, my lord? Application is dated 18/3/23, my lord. Page 24, 5.
Yes, we've seen that. That's page 51.
51 and date is on at page 52, my lord.
Yes.
18/3/23. And this page 11, what is being referred to is 17th April 24, my lord. So something transpired after application, my lord, and that is when
the incident happened.
Incident is 22, my lord. FIR is of 31st May 22. So it's clear that the application is not disclosed, my lord. Maybe he disclosed subsequently, my lord.
You applied which post?
Please, Your Lordship, I had applied for the post of Havaldar Clerk in general category relating to the state of Maharashtra.
The facts are given in a sheet, my lord. All the facts are in the case.
Where's the advertisement?
Page 41 of the writ petition, my lord.
And please, if Your Lordship will see that that's not even the ground for rejection, the ground for
Page
41, this is dated 15th February 23, my lord. 15 to 23, page 41 is the advertisement. And there was a corrigendum on 16/5/23, only increasing the number of posts, my lord.
where's the condition 28? Fine print, you.
I'll give you a better copy, my lord.
Now, can the candidature still be considered if you offered information at this stage? See, MS Lamba, what's happened here is that at the time of putting in an application, two advertisement dated a different date, or 17th February, it is. You not disclosed that there was a criminal case pending, 15th February, yes. And only later on, when you went for your detailed medical examination, that is 17 April 2024.
It's April 24.
Yeah, that he disclosed this fact, and that's why the verifications are there. Now, whether that can be taken to be suppression, of material fact which will
Yes,
disenfranchise the
please, Your
point.
Lordship, would have this next week. I'll place a judgment of the Honorable Supreme Court exactly on a similar point where the candidate had not disclosed in the first instance, but subsequently on his
I
own
brought it today.
had
We spent enough
declared
time.
about the criminal case. Then the Honorable Supreme Court.
You should have brought it today, then we will.
Please, Your Lordship, may I have it tomorrow. I can place tomorrow also.
Tomorrow will be difficult. The court won't be there. Yes.
Any written
Matters been heard substantially. Stop. MS Aslamba, however, praised that she made out to place an authority in support of her submissions in the case of petitioner just after 1 week. Yes.
56.
Kindly come with 40 next week. Yes.
56.
Very well.
You look for that also, Dr. Mozika, whether. Yes. Adone.
It pleases, my lord. My lord, as per the last order, my lord, I've impleaded the officer of KHDC.
One application for impleading?
Yes, my lord. Miss
Lordship, I'm appearing on behalf of KHDC, responding for.
Yes, this case number 13/2025. There's an application for completing the as respond number
4, my lord. 4.
For completing the the thing should be SCETI research committee to plead the executive committee represented by SCETI, KHADC. Stop. The same is objected to by the other respondents. Accordingly, the executive committee KHADC shall stand implead respondent number 4 in the writ petition, in the main writ petition. Stop. This case stands allowed. Now the main writ petition view the order passed in Miss Case WC number 13/2026. These writ committee represented by secretary shall be arrayed as respondent number 4, registry to make the necessary corrections. Yes.
Lordship, acting CM has been appointed, Lordship.
No, that was the only question on the last occasion that your Lordship had wanted some.
Lordship, we had just received instructions.
Acting CM is a dead duck, not doing anything. Then?
No, but he's still the incumbent in office.
Incumbent, yes, but if he's bereft of any decision-making power, is what's happening is very unfortunate.
Yes, Lordship.
Not this,
So
but
there's
the
an
petitioner is
overreach by the
suffering
council
for a long time
in these
now.
matters because it seems they don't have a proper understanding about how things see.
But the issue will still remain that the petitioner will be left suffering more and more as they keep conducting in this manner, my lord.
So his name Minjurlang also, but there's no Minjurlang for him.
No, Lordship. He is deprived of any actual powers, Lordship. We've actually gotten instructions to appear. The acting and his executive has engaged us just in the morning itself, Lordship. We are yet to file our power, so we'll be filing during the course of the day. But as it stands, Lordship, the acting is deprived of any actual powers or decision-making powers, Lordship, in this matter.
This thing can't be allowed to continue. When are you planning to have a proper election for the CM Swara? As a school, have to take judicial notice. You can't leave a fractured kind of eleka. What is the system of election of CM Swara?
As per
It is as per the
Act of 1959.
59.
Not 50. What is the customary process involved?
Lordship, an election will be held. An election will be held where all the electors will have a
Electors means the entire other population?
No, Lordship.
Only
The
electoral
electors-
college?
Yes, Lordship.
Represented by the clans?
Yes, Lordship.
It does appear in the Herbert's report?
No, Lordship. There's
In Herbert's report, there's nothing about CM Swara.
No, Lordship.
You sure about that?
I'll have to seek instructions, Lordship, but as per the
Roberts report 1903. They won't get it also. You know what Roberts report, correct?
Yes, Lordship.
I haven't read now.
You don't haven't read. Roberts reports done by one British Army officer. He done an extensive study that time 1903, I think. Traveled to all elecas and he documented the manner of election of
Lord,
the
I've
CM.
had a small reading of this, but I haven't gone to details, my Lord.
That's a good source of, you know.
Yes, my Lord. It does
Whether
describe the
because he
custom.
tried to just note down the custom involved. Because in every aimship there are different manners of electing this aim.
What happened in this?
Some is by electoral college, some is by, like Langren is by general public, some
Yes,
is.
So what happened in this particular instance, Lordship, is that the election was already held before the cremation of this aim. But what happened, Lordship, is that the sanat of this particular aim, which had been elected by the electoral college,
Was not granted.
by the Darbar Hima, Lordship, has not been has not
Dora
been,
Hima, no, who's the electoral college of clans that elect, correct?
the clans and the
How many clans are there?
9 clans, Lordship.
9 clans from electoral college.
12 clans.
12 clans.
Yes, Lordship. That election has been held, Lordship.
Unanimous.
Yes, Lordship. That election has been held, and without having a proper CM, without having elected a CM from the chief, the deceased chief cannot be cremated. So they had to have the election first, Lordship, and then only could the cremation take place. Now that a representation has been sent by the deputy chief in Dorbar to the district council, praying for release of the sanat. But till date, Lordship, the sanat has not been given.
Who was the person who was elected unanimously by the
deputy chief, Lordship? The deputy chief of.
He was the existing deputy chief at the
Yes,
time
Lordship.
when the last aim expired.
Yes, Lordship.
My Lord, all these issues that arises from the case of the petitioner also is because of the fact that the current acting CM was managing everything at that time. So many other things had
Current acting CM was managing.
No, Lordship.
No, in a sense,
that is
because
not correct,
the
Lordship.
yes, my Lord, previous
This Munjurla Majao.
yes, my Lord, the previous
Lordship,
CM
that
was
is incorrect,
was unwell, my Lord. So he
This
was not
acting
looking
CM,
after
this
the
acting
affairs.
CM, present acting CM was managing.
As I've told your Lordship that I've gone for site inspection as well. So I have had a word with many of the locals in and around the
that
area.
is
Same
incorrect,
way, my
Lordship.
Lord.
That's outside the area of discussion here. Only thing is that this Munjurlang Majao, you're paying for him.
Yes, Lordship. The acting CM.
And who was the deputy CM was whom?
The deputy CM was Maramdor CM, Lordship.
Now,
proper CM from the clan.
So who was managing that time? Maramdor CM was Munjurlang Majao.
Not this.
Whatever is done by the CM in Dorbar, Lordship. It cannot be delegated to
No
the
CM can
militaries.
do anything on his own.
Exactly,
It's absolutely Dorbar.
Lord, but the issue has been pending since 2022.
No,
We
fine.
have not
that,
solved
that
it,
we
and
understand
now
your pain, but if the system is not in place to where your grievance can be redressed, and what can the court do?
Yes,
There's no
That's why
proper
it's
governance.
making this inquiry as to what's happened to the putting a proper person in place.
Yes,
Lordship.
But
Lord,
that's not
into this
traveled to this
issue-
court as yet.
No.
This matter.
No, Lordship.
my Lord, the court can take suo moto.
How will it take suo moto?
My Lord, because the people
It's
will be
elected
suffering.
office. Can we?
My Lord, the people will be suffering, my Lord, because there's no
Yes,
proper incumbent.
In the main case, in view of the order of stamp period, Mr. J.K. Pariyat is present in court today and accept notice on behalf of the petitioner. So he has further apprised the court that presently there's an acting aim in place. Who is discharging the functions of this aim. Mr. L's aim, however, who has just been engaged on behalf of
the acting.
Are you a party here? His aim?
No, Lordship.
Then
this office of this aim
It's
is
just the
my Lord.
office. He's taking charge of the office of the CM, Lordship. So
is getting very, what do you call it, complicated.
Yes,
Lord,
Lordship.
very
So the
Lord.
thing is that you want to impede yourself also. Are you making a submission in the air?
Lordship, I'll have to seek instructions regarding that because
Then you have to come to implement petition.
Yes, Lordship. That is completely correct. I bow down to that, Lordship. I'm grateful for the observation.
Then what are we to do? Mr. L's aim, who's present in court, has prayed that has what do you call it? What can he say? Has Tom Shakato accepts notice, blah, blah, and says that he's in his place. Yes. Mr. Giver accepts notice, then Mr. LCM, who's present in court, has however apprised the court that he is the counsel for the acting CM who's not a party. He prays that he's allowed to file impleadment application to array himself as a party respondent. He further submits that though an acting CM has been appointed, he has not been able to function
Yes, Lordship.
or discharge duties of his office. On this submission, before the matter proceeds further, the Mr. Elsen is permitted to bring in an application for impleadment within 1 week.
Yes. Lord, may I point out one more submission, my lord, which is pertaining to respondent number 2. Respondent number 1 had stated before the court that he represents both respondent 1 and 2 because of the existing sanad. However, the sanad, if your lordship would have a look, there's no express clause or provision that gives the Soda the power to represent the executive.
Not
And in the absence of the authorization, my lord,
let the party all be arrayed, then you can make your objections. Yes. Because in the middle of this, your final relief has been watered down and he's just running around in circles. Yes. Yes, up to 2 weeks. Yes.
57.
Obliged, my lord.
57.
Now, Mr. Sakuri, what remains here?
Milord, I'll just, whatever little submissions I have, Milord, I'll please before your lordship, Milord. Give me a pointer. Milord, one thing is very clear, Milord, there's the petitioner's case and what the respondents have placed before your lordship, Milord, that gives rise to lots of factual disputes, Milord. That gives rise to factual disputes. Now, if I can take your lordship to the affidavit in opposition filed on behalf of the respondents 1, 3, 5, 6 and 10 million by the SP, that who's the respondent number 5 million.
Yes.
Well, here this is the only affidavit which has been filed on behalf of the state respondents. Now, my lord, he has averred in details and given the version of the police of the state. That means, my lord. Now, my lord, if your lordship comes to the last paragraph, my lord, here he says that paragraphs number 1, 10, 12 to 19 are true to my knowledge, belief and information. So, my lord, he is saying it on the whatever he has averred before your lordship, my lord, and paragraph 11 he is saying are matters of record. Matters of record because these pertains to FIRs which have been filed and GD entries which have been made and all that, my lord. So, my lord, the vast majority of the statements made by the SP here, my lord, is on the basis of his knowledge, belief and information. Now, but in my humble and respectful submission, it cannot be from his own knowledge. He was not there, and either it has to be on the basis of record or on the basis of instruction or information which has been received. That means whatever he has been informed by the officers under him, on the basis of that he has filed the affidavit. Now, in my respectful submission, when he was having a copy of the writ petition with him, where factual averments were in details, my lord, given, so, my lord, I would very humbly and respectfully submit, my lord, he was required to conduct an inquiry, my lord. He was required to allow the writ petitioner here also an opportunity of participating instead of just representing the case of the police department. So maybe, my lord, bona fide, whatever has been done, I'm not alleging any malafide in it, my lord. It is bona fide only. Whatever has been done by him is bona fide. He has brought before your lordship whatever he has been instructed and he has been told, my lord. But it cannot be taken to be a gospel truth, my lord. because it is, if it is actually from his own knowledge, he was a participant there, he was there, then that would have been. So, Milord, in this given situation, Milord, my only submission at this stage is, Milord, your Lordship may direct for an inquiry, Milord. A proper inquiry may be done, Milord, by a competent authority, Milord. That is my only submission. Instead of accepting, Milord, whatever is the version which has been submitted before by
See, what about the BSF affidavit?
BSF affidavit, Milord. BSF affidavit. BSF has made out a case, Milord. BSF's affidavit is directly in contradiction to the factual averments made by me, Milord. My factual averments is that the cattle was seized in the daytime, and it was seized from the village while the cattle were grazing. And the BSF says, Milord, that they were trying to cross the international border, and at that time they were apprehended, and it was apprehended at night. So there is a clear dispute of facts, Milord. So,
no, but then in the affidavit say that 30 cattle were found grazing, and they were found that they were seized by the BSF 18/5/25, and it was found 14 belonged to one James Mueller.
That has been said, Milord.
And then 16 belonged to this lady, whoever. I mean, some Ibadi Shishawar. And those cattle were returned back to them.
So that is because, Milord, that is because in the police station the FIRs were registered, Milord, and on the basis of the registration of the FIR, this has been done. Now, whether there is any element of truth in that or not, Milord, or whether it is manipulated.
Your cows, then your cows don't. They have the according to after the SP said that you could not explain as to how the cows traveled.
No opportunity was given to me, Milord. That is what my case before your Lordship. If an opportunity, a reasonable opportunity may be given to me for
She was asked, on inquiring as to how her cattle reached Shella area from Balad, she could not give any satisfactory reply and could not prove the cattle belonged to her. And hence the petitioner made up a story that she kept the cattle in Tham village.
So that is their version, Milord. Whereas our version, Milord, in the writ petition, your Lordship will find that we have categorically stated that in this Tham village, Milord, the cattle were kept there. That is near that is near Shella only, and in that village only the cattle were kept. There were people who were taking care of them, Milord, and they were forcibly taken away during the daytime, Milord. So there is a contract, and we have also annexed, Milord, certificates issued by the village authorities. We have annexed that to it. Milord, Milord, if I am allowed an opportunity to participate in an inquiry, Milord, by an appropriate authority, Milord, I would very humbly submit, Milord, if a magisterial inquiry is allowed, Milord, in this.
Yes, Mr. Sukant. First, okay, Indian.
Milord, any inquiry at this stage, Milord, what? Milord, I don't think there are any biometrics of those cows, Milord. It's to identify which were those 30 cows, Milord. But that is the practical difficulty, Milord. And based on the inquiry, Milord, it was discovered that James Mueller and they were found to be the owner and is returned to them, Milord. Now there is a property dispute with regard to ownership of the cows, Milord. No inquiry will give any result at this stage, Milord. At the best, they can file a civil suit or pursue some other remedy.
Yes, of the state also, my lord, same, because my lord, there is a disputed questions of facts, my lord. This cannot be adjudicated in this writ proceeding, my lord.
So, my lord, if it cannot be adjudicated, that if they have wrongfully given the cows to somebody, my lord, then the state is to compensate for that, my lord.
This should always
we'll pass orders.
establish
Hearing concluded.
Obliged to you, Lord. Highly obliged.
We can't keep on arguing till the cows come home. But this, you see, the border is very dodgy, you know, especially with this cattle. Anyway, we'll pass orders. Yes, you might have right.
The system has to function. Whatever, Milord, the system has to function, Milord. Obliged, Lord. Outright rejection to bata diya.